Thank you very much, Andre, and good morning, everyone, and welcome to Oxford, those of you who don't already live here or work here or study here. It's my enormous pleasure to welcome you to this third Oxford Symposium on Comparative International Commercial Arbitration. This event, as Andre was saying, is jointly organised by a number of people, but by two organisations, the Oxford International Arbitration Society and the Commercial Law Centre at Harris Manchester College, Oxford, of which I am the director. Now, the Commercial Law Centre is a college-based centre, but it has three aims, and this conference, this symposium, which has now been going for 3 years, and we hope it will be going for a lot longer, ticks all the boxes as far as our aims are concerned. So the Commercial Law Centre aims to provide an environment for high-quality research in all aspects of national, international, transnational, and comparative law relating to commerce and finance. And so it is very appropriate for us to be jointly organising a conference with speakers and participants from all over the world. The conference is overtly comparative, so we have in each panel we have speakers from different jurisdictions, and they're discussing the law and practice in their own jurisdiction and comparing and contrasting it with the position in other jurisdictions, as well as thinking about the global position. So we are really very comparative. But we are also very international. You can't really get more international than international commercial arbitration and the law relating to it. By definition, it's dealing with disputes which arise between parties from different states, usually about events which happen in one or more different states, frequently governed by contracts which are subject to the law maybe of yet another state or states. And this internationality is reflected in all aspects of the process, particularly in relation to the arbitral organisations, which is the subject of one of our panels today. So to take us a few examples, I looked up some websites. The Chartered Institute of Arbitrators said on its website, "We support more than 15,000 alternative dispute resolution practitioners in 133 countries around the world." The LCIA says that the international nature of their services is reflected in the fact that over 80% of parties in pending LCIA cases are not of English nationality, despite the fact that it's based in London. And the ICC says that every year it appoints more than 1,300 arbitrators from 77 jurisdictions. So it is an international enterprise, and it's wonderful to see people from so many countries here today. Turning to transnational law, which is an interest of mine, transnational commercial law, transnational law that is produced by the various transnational and international private law organisations such as UNCITRAL and UNIDROIT. So really, arbitration is a shining example of transnational commercial law because, of course, you have the New York Convention. There are now 159 parties to the convention. I knew that, I looked it up yesterday, and there are new additions even now and being added every year. So this year, the Cabo Verde and Sudan became parties, and this is happening all the time. And if you compare that to other transnational commercial law conventions, it's really very impressive. There are only 89 parties to the Vienna Convention on the International Sale of Goods, and the Cape Town Convention, which is the convention I know most about and am most involved in, only has 77 contracting states, although that's much more recent, of course, than the New York Convention. Now, the second aim of our centre is to provide an opportunity for interaction between academics, practitioners, and policymakers. And here we have a perfect example of this interaction. So all of our speakers or attendees fall into at least one category. Many fall into 2 or 3 of those categories. And it seems to me that international commercial arbitration is an area of law which really does provide a genuine marriage between theory, academic enterprise, and practice. So you can discuss issues at a highly theoretical level, but also these issues actually affect real cases. They actually arise in practice. And so we're very pleased to welcome you today to further that intellectual endeavour, where we have academics and practitioners on the same panel trying to work out what the law is and what the law should be. And our third aim is to nurture and encourage the commercial lawyers and researchers of the future. And again, this conference is wonderful for us. We have a number of early career academics and practitioners who are involved in organising and even speaking at the conference, but we also have 70 students registered to attend this event. Wonderful to see probably all of you here. I'm very impressed you've all managed to get here so early in the morning, as being students. And I'm delighted that we're able to provide an opportunity for all of you at the start of your careers to hear the wisdom of the extensive experience that our speakers have today. And I do hope that all the students will use the opportunity while you're here to ask questions, to enter the debate, and to talk to the people who are here who have many years' experience in international commercial arbitration. Now, we have two very distinguished keynote speakers, and we're very fortunate today. Our first keynote is going to be given by Lord Mance. And in a change to the published programme, he will speak after the first panel. We've had to change that. But he's going to come and he's going to talk at about 11 o'clock. And you'll probably hear more about him later on, but I wanted to just emphasise how fortunate we are to have him. I know him quite well. Lord Mance was until last June this year the Deputy President of the UK Supreme Court, and he is now in practice as an arbitrator. Before he went on the bench, he was a leading commercial barrister. He specialised particularly in insurance law, banking and international trade. He went on to sit in the Commercial Court in London and then the Court of Appeal. He sat for 13 years in our Apex Court, 4 years in when it was the House of Lords, and 9 years as a Justice of the Supreme Court. It's particularly appropriate that he comes to Oxford. He has many Oxford connections. Of course, he came here as a student, but he is now actually High Steward of Oxford University, and appropriately, he is now an Honorary Fellow of Wolfson College, this college where we are. So I've heard him speak on many occasions. He's very knowledgeable, very wise, very interesting and eloquent. We are in for a real treat. Now, our other keynote speaker, I only met this morning, so it's lovely to meet you, Hosea Manuel Emilio Nunez Pinto. So I have to look on the web to find out my knowledge of, find out information about him. But I think I could describe him as arbitration royalty. One website describes him as Brazil's most influential arbitration practitioner, and it's difficult to overstate his importance within Brazil's arbitration bar. He was involved in drafting Brazil's arbitration law. He's helped create the Brazilian Arbitration Committee. He served as an alternate member for Brazil in the ICC International Court of Arbitration and has sat as vice president of that court, and he's now a member of the LCIA Court of Arbitration. So he's clearly had been very, very influential in arbitration law in the last few decades, and we're really fortunate to be able to hear from him later this afternoon. Now, lastly, before I turn it over to the substantive part of the day, I'd like to thank the members of the organising committee. On your programme, you will see that my name appears as one of them, but to be honest, I'm a total fraud because I have done very, very little. They have done everything. They've been absolutely wonderful. They've organised the programme. They put everything together with Wolfson College. They've absolutely organised everything. So I'd like you to join with me in thanking Andre, Felipe, Juan and Tom for everything they've done so far and everything they'll do to make this conference a great success. So thank you very much. I hope you enjoy it all. I apologise I can't stay for the whole conference, but unfortunately I have to do that thing that we call teaching, where we have to, interact with some students. Many apologies, but I will come back later. And I really hope you enjoy the rest of the day. Thank you very much indeed.